Thank you for allowing me to come here and talk about the CLEER Act and the ORDEAL Act. As Pete mentioned, with the CLEER Act, what we're looking to do here is simply bring some common sense to the EPA's approach. My family has been in Arizona since 1878, when it was a territory. These dust storms that we're talking about here rolled through the territory at that time. They do today, and they will long after my family is gone.
And they went straight from there to Oklahoma.
That's right. It's much like tornadoes in the Midwest or elsewhere, or hurricanes that come. It's simply a natural event. The problem is the EPA simply won't treat it as such. The CLEER Act will simply ease the regulatory burden of states, including arid states like Arizona, from these exceptional events. When these dust storms occur, they cause a spike in the particulate level, and this blip will have a dramatic regulatory impact on the states. They'll be found in noncompliance, and even though, as I mentioned, it's no fault of their own. And due to federal air quality standard regulations, it leads to penalties like loss of federal transportation dollars. Now, faced with repercussions that they did nothing to cause, states end up dedicating vast amounts of manpower, countless work hours, considerable financial resources to reviewing these events that, as I mentioned, they don't control. Yes, for example, the Arizona Department of Environmental Quality, Maricopa County Air Quality Department, Maricopa Association of Governments, in 2011, 2012, spent about $675,000 and 790 staff hours to provide, or just to prove that the spike in PM10 levels was caused by a dust storm and not by pollution. Again, $675,000, 790 staff hours, just to say it was a dust storm. Historically, EPA's reviews under this exceptional event rule have been arbitrary, cumbersome and costly, and they have lacked an appeals process. We're simply saying, let's introduce a little common sense. The CLEER Act would simply require a rulemaking and require that decisions on such events be based on the preponderance of evidence, and it would accord deference to the state's own findings of when such an event happened. It would also require the EPA to review states' exceptional events documentation within a reasonable time period. As Pete mentioned, you wait and wait and wait for the EPA to actually review this. They drag it out, and as I mentioned, there's no appeals process either. If being wrapped around this regulatory axle isn't enough, Arizona will soon face the already stringent air quality standard for ozone. And that's why I've introduced the ORDEAL Act. When the EPA reduced ozone standards in 2008, as we know, counties across the country that were in non-attainment were forced to enact further expensive and complicated compliance plans. Now, relying on what I think we all can accept are some dubious scientific basis, the EPA has proposed lowering the ozone emission standards even more to 65 parts per billion, while accepting comments, as mentioned, to even lower it even further to 60 parts per billion. By some estimates, as I'm certain the committee is aware, the proposal to lower ozone level may be the most expensive regulation in history, as the chairman mentioned, costing as much as $1.7 trillion. And lowering ozone standards from 75 parts per billion to 65 parts per billion would cost a whopping $140 billion annually. Now, the EPA's own science advisors disagree on the very basis of this regulation. Simply put, the lowering of the ozone standard is unnecessary. U.S. air quality has been improving for the past 3 decades. Since 2000, air quality has improved by 18% due to lower ozone levels. Now, we all recognize, as Pete said, we'd love to have lower ozone levels. A lot of that is natural, that it occurs naturally. We all accept that you couldn't lower it to 45 parts per billion. It would be just unreasonable. So there's some standard that's reasonable and some standard that's not. It's not that we all don't want the same goal of cleaner air. We just have to figure out what that standard is. And As mentioned, there's a 5-year review process. What the ORDEAL Act would do would give states flexibility and time to implement their own innovative and proactive measures. And the bill, most importantly, would extend all air quality standards review, including ozone, to a 10-year timetable instead of the current 5-year period. That would give a little leeway and allow the states and all of us to breathe a little easier. Thank you for your time.